12 million in current year, 12,047,000. It's come down by 500 half a million.
Hello and welcome to our Talk Tech webinar series. This is week 5 of a 5-week virtual mini-series, or week 4 of a 5-week virtual mini-series on startup equity opportunities. This mini-series will help you learn what investors are funding, how to protect your IP, different equity funding options, and how to build a strong team. Talk Tech webinar series is brought to you by the SBDC at UCI Beal Applied Innovation. The SBDC is funded in part by the U.S. Small Business Administration and State of California Governor's Office of Business and Economic Development and other sources. The SBDC is here to help you start, grow, and succeed in your business by providing no-cost expert consulting and trainings such as this fantastic webinar series. A little housekeeping before we begin. Everyone is muted during the webinar. All webinars will be recorded and sent to all attendees after the webinar has concluded. Once the webinar concludes, a brief survey should appear. We would love your feedback and would also like to know what other topics you are interested in learning about. Tomorrow, the recorded webinar will be sent to all participants. A PDF copy of the slides will also be included in the Dropbox link. There will be a question and answer at the end of the presentation, but please feel free to ask questions during the webinar by clicking on the Q&A box at the bottom of your screen. Once the presentation concludes, I will ask the questions presented in the Q&A box or chat feature. I may not get to everyone's questions, but we will do our best. If we don't get to your questions, please email khaledh@uci.edu. This week, we have the pleasure of hearing from Azad Virk. Azad is a shareholder in Stradling's corporate and technology transactions practice groups. Azad focuses on a variety of corporate, commercial, and intellectual property transactions. Some of them include the formation of startups, joint ventures, intellectual property, and technology transfers across multiple industries. Today, Azad will be talking to you all about the legal structures of entities, what option is right one for you, the pros, cons, and costs. He will also give an overview of registration and how to do it in incorporation. Thanks for speaking today, Azad. I'm going to turn it over to you. Thank you.
Philip. So I'll start the presentation by saying that by giving a disclaimer that the information that's going to be presented today is general information. Choice of the right legal entity depends on each person's specific fact situation. You should always consult with your attorneys and or accountants to determine what's the right structure, what structure is the right one for you, depending on how, what you intend to achieve, how you want to go about your startup. Having said that, from a formation perspective, these are the three things that I would like to address today. One is, why do I need to incorporate? The second is, what is the form of entity that one should look at? And the third is the state of incorporation. A lot of times, folks come in. I work a lot with startups and emerging growth companies. A lot of the times, founders would come and meet me, and the question that they have is, hey, do I really need to incorporate? I'm working on an app. I'm going to be building this app myself. Should I, I may have one or two people helping me out. Should I spend the money to incorporate, or should I wait to see what happens with it? There are a few things that one should keep in mind. One is that the incorporation, it limits your liability. It limits your personal liability. The second is, there could be tax reasons for why you should incorporate. The third is, if you're a tech startup, intellectual property is one of the main assets that the company is going to have. Intellectual property is what the company is going to commercialize going forward. Intellectual property is what is going to get investors into the company. It's very important that intellectual property is properly assigned and belongs to the company. Now, if you are working, as an individual, and you've hired you've had a friend working with you, but you didn't document the IP properly, the IP wasn't transferred to the company, then you have cleanup issues right from the beginning. So that's another thing that one should keep in mind. Then, of course, equity ownership. As a founder, you want to incorporate, you want to start your company, and then have proper equity distribution amongst the founding team. Then having an incorporated entity, it helps you to raise capital. It allows for investment from be it friends and family, be it angel investors, be it institutional venture funds. They look for an entity to invest. And last but not the least is the legitimacy. If you have an entity and that entity is formed, and you've built an app, and now you're trying to see if the app works. You're trying to get into some proof of concept trial kind of engagements with third parties. Having an entity always brings that legitimacy to your business. Now we come to the form of entity. There are various forms of entities that are available. You have sole proprietorship, which I kind of alluded to earlier. You are a founder. You are building an app yourself. You're building an app yourself and with a couple of friends. You could always be a sole proprietorship. The second is a partnership. You could have your friends as partners in your partnership, and you could divvy up you could divide the partnership interest amongst each other, each of the founders. That's another option that you have. The third is the S corporation. We will talk about the S corporations a little later. And the fourth is a B corporation, a benefits corporation. Now, each of these foregoing, each of these entities have their disadvantages, and those disadvantages outweigh the benefits. For example, we've already talked about sole proprietorship. It doesn't get you it doesn't limit your personal liability. Likewise with partnership, it doesn't protect you, doesn't get you the limitation of liability that a corporation or LLC would. So here's a chart, and basically kind of lays out the types of entities that are available, right, from C corporations to S corporations to LLCs, partnerships, and sole proprietorship. And it also talks about, various features which are available to the different entities. So for example, sole proprietorship, it's as the name suggests, it means just yourself. Does it get you limitation of liability? No. Is it tax efficient? No. Is it you are basically trading as your own entity, so obviously there's no accounting or legal fees, but then it also means that you are pretty much on the hook for whatever the liabilities of the business are. We've already talked about, we'll talk about the C corporations, LLCs, and S corporations as we move forward. We already talked about the partnerships. So really from if you have a tech startup, a typical tech startup that, you building an app, you're building a widget, or, you have a med device company, and you started in your garage, and then you will hire a team that'll help you create an MVP. Then you will reach out to potential customers, see if you're getting traction. Then you start reaching out to angel investors to get that seed funding going, and eventually get to the the bigger rounds. For a tech startup that follows that conventional path, there are really two types of entities to start off with: the C corporations and limited liability companies. Now, corporation. Now, corporation is by default a C corporation. When you incorporate be it in Delaware, in California, or any other state, by default you are a C corporation, and you have to file a form to be S Corp, and we'll talk about S corporations. Now, a corporation, there are certain features that are common between C and S corporations. It is a distinct legal entity. It's owned by the stockholders. So the stockholders are actually the owners of the company. The stockholders elect the board of directors. The board of directors are responsible for managing the corporation. They lay down the policies. They determine the direction of the company. Now, the board of directors then, in turn, they appoint the officers of the corporation, and the officers of the corporation are responsible for managing the day-to-day operations and business of the company. So in a way, the corporation, it's a pretty standard structure. A corporation will have stockholders. There are essentially three types of people, or three. There are three within a corporation. There are three stakeholders. One are the stockholders, who are ultimate owners of the corporation. Then there's a board of directors. The board of directors, as I said, they determine the policies. They are responsible for managing the corporation. Now, the board of directors have fiduciary duty to the corporation. They have to act in the best interest of the company. They have a duty of good faith. They have a duty of loyalty. And the board of directors, in turn, then will appoint officers. The chief executive officer, the treasurers, the secretary, the vice presidents. All the officers are determined or appointed by the officers. And the officers, in turn, based on the policies laid down by the board, based on the direction that the board lays down, the officers are responsible for managing the day-to-day operations, essentially pushing the corporation forward. Now, there are certain advantages with the C corporation. It's more traditional. It's definitely favored by the VCs. We have a lot of instances. We come across I've come across lots of instances where an LLC, a company was started off as an LLC, went out to raise money. Yep, friends and family around. Friends and family is friends and family. They're investing in the founder, and they don't care so much about the form of entity. But when you start talking to more professional, sophisticated investors, be it the angel investors, be it the early stage VCs, absolutely the later stage VCs, they want to see corporations. They understand the structure very well, and that's what they require. So in my experience, I've never seen a venture fund invest in a LLC, and there are certain reasons for that. Then the second advantage is that it limits liability for the stockholders. So the stockholders are not personally liable for the liabilities of the business. And it can be party to a tax-free reorganization merger, and then there is no need for change of entity for an IPO or an institutional investment. As I alluded earlier, the institutional investors, they prefer the corporation as a form of entity. Now, there are certain disadvantages, particularly so with a C corporation. There is double taxation, so the corporation gets taxed at the corporation level, and if the corporation then distributes dividends or distributes assets to the stockholders, then the stockholders get taxed at the stockholder level, at the individual level. So there is that disadvantage that a C corporation gets taxed. There's double taxation. And a lot of the times this question gets raised by founders, and why should I then set off as a C corporation if there's going to be a double taxation? In a tech startup, it takes a few years and multiple rounds of financings, before the company gets profitable, and before the corporation really has to think about being hit by taxes at the corporation level, and before the corporation actually distributes any dividends to the shareholders. So although, on paper, yes, there is double taxation, but from practical standpoint, it doesn't really come into play until the corporation has matured into at a much later stage. Then the second disadvantage with a corporation is that it is less flexible. As we saw in the earlier slide, the corporation has to have a board of directors. The board of directors then appoint the officers who are responsible for the day-to-day operations of the company, and the stockholders are the owners of the LLC. There is a little bit of there's less flexibility with the corporation. The board member, the directors and officers, they owe fiduciary duties to the companies, to the company. S corporation, as I mentioned earlier, when you incorporate a company, be it in Delaware, be it in California, be it in any state, by default it's a C corporation. You can choose. You can you have to fill in a form, send it to the IRS, and from a tax perspective, you can choose to be a S corporation. Now, S corporation has the pass-through advantage. So the S corporation doesn't get taxed at the corporation level. So there is only a single layer of taxation at the stockholder level. So there is that advantage, but there are it has limited ownership. We'll talk about that in the next slide. Although there's no tax at the corporate level, but like I said earlier, if you're a tech startup, it's going to be a few years before you really have to worry about being taxed at the corporate level, or before the company starts distributing profits to the stockholders, and the stockholders then have to worry about being taxed at their level. But S corporation, absolutely, it is a pass-through entity. And taxes at the owner's level, which is stockholders' levels, and the tax rates are determined based on each stockholder. The dissolutions are usually taxable. The distributions are tax-free, and of course, like a C corporation, it limits the liability of the stockholders for the liability of the company. Now, there are certain disadvantages why S corporations are, as compared to C corporations. One of the major disadvantages is that in a S corporation, entities cannot be shareholders. So the S corporation shareholders, only individuals can be shareholders of a S corp. Now think of it, if you're out there trying to raise money, angel investors mostly invest individually, so not so much of an issue. But even these days we are seeing even angel investors are forming angel funds. But if you have a S corp, then an angel fund cannot be a stockholder, cannot invest in the company. Likewise, VCs are almost always limited partnerships, sometimes LLCs. So those they cannot invest in an S corp. S corp cannot have more than 100 shareholders. Only U.S. citizens and residents can be shareholders of S corp, and there can be only one class of stock. Yeah, you can only have common stock or preferred stock, but you can say you can have voting common stock and non-voting common stock, but you cannot have a common stock and a preferred stock. And that's that. So a couple of things that I would like to add at this point is that with the S corp, as I mentioned, since entities cannot be shareholders of S corp, if you end up issuing shares to an entity, that blows essentially blows the S election. Secondly, S corp cannot have two types of stock, and if you're looking at doing an equity round where the investors are going to invest in the corporation, almost always the investors would want preferred stock. The common stock is for the founders and service providers of the corporation. When the investors are seeking to do an equity round, they're almost always going to insist on preferred stock. Now, the preferred stock, has certain rights, preferences, and privileges that are superior to the common stock, and the argument essentially is that the investors, with those rights, preferences, and privileges, the investors are trying to protect their investment. They are investing in your business, but at the same time, they want to seek some protections. But that is not possible with the S corp. On the other hand, with the C corp, there's no restriction on entities being shareholders. There's no restriction on having multiple classes of stock. Within a class of stock, you can have multiple series of stocks. You start off with a C corp. If a typical path, like I said earlier, is if you're doing a seed round and you end up raising money through convertible notes or safes, even those convertible securities will one day convert into preferred stock. If you're doing an equity round, and even if you start with the CD seed equity round, the CD seed is almost always going to be a CD seed preferred stock, which is going to be a different class of stock than common stock. The common stock, like I said, is meant for the founders and service providers. So like I said, the investors will insist on preferred stock, and if you have a C corp, there's all you have to do is amend your charter and create a new series of a new class of stock. Now, you can start off as an S corp, and if you're S corp at the time when you're doing an equity round, you can absolutely convert into a C corp, and that is that's a lot of the times that's what the founders insist on doing. That like I said, S corp has certain pass-through advantages. The profits and losses get passed through to the stockholders, and hence some founders, some entrepreneurs see benefits of a S corp. Now, converting from an S corp to a C corp is relatively easy. You fill up a form, send it to the IRS. It can be done. From a process perspective, it's fairly simple. However, with the S corp, there's a qualified small business stock tax advantage, which is only applicable to C corp. So if you've held shares of a C corp for 5 years, and if you otherwise qualify, there are certain requirements. If you meet those requirements, then there are certain tax advantages with holding shares of a C corp as opposed to S corp. Now, that qualified small business stock tax advantage does not extend to S corps. So that's one thing that if you want to set up an S corp, that is absolutely a discussion that you should have with your attorney or your accountant. Understand the nuances, understand the differences between a C Corp, S Corp, understand the qualified small business stock, and see if that's an advantage you want to take. Next, we move on to the formation. What are the formalities? What are the steps to form a corporation? Now, so the corporation has, the way to set up a corporation is to file your certificate of incorporation or the articles of incorporation, depending on, some states call it certificate of incorporation, some will say articles of incorporation. Delaware, it's certificate. California, it's an articles of incorporation. You essentially file your certificate of incorporation with the Secretary of State. The Secretary of State will stamp it, send it back. That's when you receive your certificate, stamped certificate back, that essentially is that incorporates the company. After that, you're required to, you're required to pay your filing fees and license fees. You prepare and adopt bylaws of the corporation. Now, the articles of the corporation is the charter that you file and you receive back from the state. The bylaws are essentially the belts and suspenders. It kind of lays down how the operations of the company are going to be run. How the stockholders meetings will be held. How the board of how many members can we have on the board of directors? How the board meetings are to be held. All those belts and suspenders go into the bylaws. Now, the bylaws are an internal document of the company. They don't need to be. They are not required to be filed with any state. But once you receive the charter, then the very next step is for the incorporator to essentially resign, appoint a board member, and adopt the bylaws. Now, the board member then takes over once the incorporator is resigned. The board member then takes over and appoints the officers and issues the equity to the founders. Then, as a corporation, you should have a minute book. The minute book essentially is where all the, where the certificate of incorporation is stored, where the bylaws of the corporation are stored, where the stock issuance certificates are maintained, where the securities filings are maintained. That's essentially the book that, eventually when you're out there trying to raise money, you will get a diligence request list from your investors, and they would like to, the diligence request would typically have, hey, show us your charter, show us your bylaws, show us your securities filings. If you have a properly maintained minute book, then it's fairly straightforward to address the diligence request list, and that it just makes it that much easier to raise money, raise capital. And it's very important to understand that, once you form the corporation, you need to follow the corporate formalities. As I mentioned earlier, the board of directors is responsible for laying down the policies so a lot of the actions, for example, appointment of officers, issuance of equity, opening up bank accounts. These are actions that required board consents or board approvals. It's very important in a corporation that the corporate formalities are followed. It is very important to also not only that, from a documentation perspective, like I said, it helps you to go out and raise capital, address the diligence request lists that the investors set out, but also to keep that limitation of liability that a corporation brings. It is also important that the corporation follows the formalities. One of the things that the courts eventually, if the corporate formalities are not followed, that's one of the things that the court would look to see whether it'll lift the corporate veil and make the stockholders liable for the liabilities of the business. So it's absolutely important to follow the corporate formalities. Now, standard terminology in a corporation, once you form the corporation, you have adopted the bylaws, you have the minute book. So some, there's some terminology that's associated with corporations. It's authorized stock and authorized shares. Now, that's what goes in the charter. when you file, if you form a company, if you incorporate a corporation, your charter will authorize the number of shares that the company is allowed to issue. It'll also say the class of securities that the company is allowed to issue. Typically in a tech startup, we almost always start with common stock, authorize a certain number of common stock. The corporation cannot issue more than the number that's authorized in the charter. Then there's the concept of issued and outstanding shares, and it's very important to understand the difference between the authorized shares and the issued and outstanding shares. Now, like I said, authorized shares is the number that goes in the charter. That is the number that the corporation is allowed. That is the number of shares that the corporation is allowed to issue. But the corporation may not end up issuing all the shares. It may end up issuing, a fraction of the shares that have been authorized. And in almost always in tech startups, the founders, even if there are even if there is a team of founders, the founders will not end up issuing all the authorized shares to themselves, because in a startup you want to have a cushion, because you may want to go out and hire more team members, issue out options. You may use common stock to raise capital, from friends and family. So there's always a cushion that you maintain. Now, the number of shares that are actually issued is the issued and outstanding shares, and that determines, very important to understand, that the number of shares that the corporation issues or has either issued or has reserved to be issued determines the ownership percentage in the corporation. Authorized share number could be higher, much higher, but it's the issued and outstanding shares that determine the ownership percentage. Then, options and warrants. Options, typically stock options are what the corporation, once you reach a certain stage where the corporation has value, the shares of the corporation have certain value, then it becomes, from a tax perspective, it becomes prohibitive to issue out shares to your team members, to your new hires. That's where you end up using options. Now, to issue out options, you will authorize a stock incentive plan. You will authorize you'll reserve a certain number of shares in that plan, and you will use that plan then to issue options to your new hires. Warrants, options issued outside of a plan are pretty much warrants. Both those things are essentially the right to buy stock at a certain value, at a certain exercise price. The exercise price typically is the fair market value of the common stock on the date that the option is granted. Then we have the concept of fully diluted shares. Like I said, there's a concept of issued and outstanding shares. Then you may have reserved certain shares in your stock incentive plan. Then you may have issued certain convertible securities and safes and convertible notes. The issued and outstanding shares is actual shares that have been issued. The fully diluted shares is on a fully diluted basis, you include the option pool, you include the convertible securities as well. Capitalization and cap table, those are terms that, when you're talking to investors, the investors would like to see your cap table. The cap table essentially lays out, how many shares have been issued to the founders, what's the ownership percentage, how many shares have been reserved in the pool, what convertible securities have been issued, how would those convertible securities convert, and essentially gives the complete picture of the company's capitalization to the investors. Limited liability company. So limited liability company, like I said earlier, there are really two types of entities that tech startups can consider: the C corporations and limited liability companies. Now, I also mentioned earlier that VCs, institutional investors, sophisticated institutional investors will almost always invest in C corporations. But we do have entrepreneurs that have founded their companies as LLCs. What then happens is that before the investment, then you have to convert the LLC into a corporation. That's almost always a condition to financing. Like a corporation, the members of the LLC are the ultimate owners of the entity. So there's a little bit of a difference between the terminology. As opposed to stockholders in a corporation, in an LLC you have members. Now there are certain tax advantages to the LLC that are not provided to C corporations. LLC is a pass-through entity, so there's no double taxation, no taxation at the LLC level. Profits and losses are passed through to the members. And if you can qualify, initial years there are obviously losses, and certain people like to use those losses to write off other sources of income that they may have. Of course, if you can qualify, you could use those losses to write off your income. So there's no double taxation. Then in a LLC is a very flexible structure, much flexible structure than a C corp. You may have a board of managers, but you're not required to have a board of managers. It could be a member managed LLC. You may have officers, but you're not required to have officers. The members could just divide the responsibilities amongst themselves. Then the traditional legal concepts like fiduciary duties, I had alluded to this earlier, that the board of directors in a corporation owe fiduciary duties to the corporation, the duty of good faith, duty of loyalty. In a LLC, you can have those, but the board of even if you decide that you'll have the board of managers, the board of managers can waive the fiduciary duties. Which is not possible with the LLC, with the corporation. Sorry. Now, there are certain advantages with the LLC. Like a corporation, it's limited liability. Like I said, the members of the LLC are not liable for the liabilities of the LLC. It is a flexible structure. It's based on a contract. So you have an operating agreement, and the operating agreement is essentially the nuts and bolts of how the LLC is going to be managed, who's going to have what responsibilities, who's going to have what rights. How the profits and losses are going to be distributed. Everything goes into an operating agreement. It's sort of like it is a contract. It's essentially a contract between the members. You can set up the management whichever way you want. You can set up distributions whichever way you want. Now, can be flow through for tax purposes. We talked about that. It can provide for special allocations and distributions. Like I said, it's a flexible structure. Allocations and distributions can also be set up. It can replicate to a large extent. It can replicate the same preferred stock, common stock structure that a corporation has. You can replicate that in a LLC. However, one of the biggest disadvantages with the LLC is that it's not favored by the venture capitalists and the VCs. Generally, the VCs, especially in even angel groups and angel funds, we see that they tend not to invest in LLCs. There is a reason for that. Now, the pass-through structure of a LLC or a S corporation, for that matter, it could work well for an entrepreneur. Like I said, profits and losses pass through. If you're passing through losses and you have other sources of income, you can write off those. So long as you qualify, you can write off those losses against other sources of income. However, that same structure, doesn't work for the VCs or sophisticated investors, because the VCs because these investors are not only investing in your entity, they are investing in other multiple entities, right? And if at the end of the year they have to wait for each entity to report the profits and losses, issue a K1 to the members, and then they have to collect K1 from the multiple entities that they have invested in, and then file their returns. It's an accounting nightmare. And keep in mind, a lot of these VCs are themselves pass-through entities. Some of these, some of the VCs, the funds of the funds, they require their VCs. They mandate the VCs that they will not invest in pass-through entities. So LLC structure, for multiple reasons, doesn't work for venture capitalists. Then there are, of course, there are some self-employment tax issues in connection with the LLCs, which, if you're forming an LLC, something that you should talk to your attorney, something that you should absolutely talk to your accountants as well, understand what those self-employment tax issues are. Like I said, equity owners have, if you are a LLC, then I'm sorry, if you're a member in an LLC, then the LLC issues you a K1, and then you have to, report that, use that K1 to file your own taxes, and you may have to file tax returns in certain jurisdictions where the LLC is formed. Now, giving out equity in LLCs is more complex. Like I said, it's a contract. It's everything goes into an operating agreement, but it just makes the operating agreement a really complicated document. A lot of the people don't understand that. And everyone has to sign up to all members have to sign up to the operating agreement. So sometimes it becomes difficult to explain the distributions, allocations of distributions to each member who's signing up to the operating agreement. Then the legal and accounting costs are often much higher, and the reason, of course, is pretty clear that as a LLC, you're a pass-through entity, so you're required to that operating agreement that you have will be reviewed by is essentially the nuts and bolts of the company that determines the distributions. You need sophisticated legal counsel who understands the waterfalls, who understand how to set up the waterfalls, and you absolutely need sophisticated accountants as well to make sure that they are allocating the distributions properly. And at the end of the year, they have to issue out, the LLCs have to issue out K1s to the members. I would, at this point, I would also like to mention that, I think I alluded to this earlier, is that, even if you are a LLC, if you want to go out and raise money through sophisticated investors, those investors would require you to convert into a C corporation or into a corporation. Now, converting LLC into a corporation is not as straightforward as converting an S Corp to a C Corp, where you just have to fill out a form, send it to the IRS. Converting an LLC to a corporation, you have to go through a conversion process. You have to file a certificate of conversion in the state where you're going to set up your corporation. You have to file the certificate of incorporation in the state where the LLC is formed as well. Now, if the cap table of the LLC is complicated. You've issued multiple layers of membership interest. You've issued profits and interest units. Then it becomes that much more complicated to convert an LLC into a C corporation. So sometimes conversion of LLCs into a C corporation itself becomes an expensive process. That's something that one should consider upfront. If the strategy is to bootstrap the company for a few years, then yes, as LLCs definitely have certain advantages. But if the strategy is to go out and raise capital pretty quickly, in a matter of a few months, then one should consider whether whether those tax advantages would really be meaningful for the LLC, or the cost that you would incur in first forming the LLC and then converting into a corporation, whether the cost is that cost outweighs the benefits. Now we'll go through the formation process of LLC. You file the articles of organization with the Secretary of State. It's a fairly simple document. As opposed to a corporation, there's no authorized stock. You don't need to authorize any units in your articles of organization. It's very straightforward. Once you receive that back from the Secretary of State, the LLC is formed. Then you have to pay your filing fees and licensing fees. The most important document in an LLC is the operating agreement. The operating agreement in the LLC is essentially the certificate of incorporation and the bylaws of a corporation merged into one. So the operating agreement is a document that needs to be that one needs to be very careful in setting up that operating agreement. It's, like I said, it sets forth the the way the LLC is going to be managed. It sets forth the allocation, the profit and loss allocations, the distributions. So that's a document which is the foundation of the LLC. And then, of course, you have to file your reports with the Secretary of State. The key distinctions between corporation and LLC, I've already alluded to some of them. In a corporation, you have stockholders as the owners, and so there's a little bit of difference in terminology. Stockholders as opposed to members, shares as opposed to membership interests, options as opposed to profits interest units, operating agreement as opposed to charter and bylaws, board of managers as opposed to board of directors. So there's the terminology is different. A lot of the times, especially in the tech startups landscape, folks are very familiar with the terminology for the corporations. They're familiar with stock options. They're familiar with the concept of stockholders. They're familiar with the concept of preferred stock, common stock. So it's much easier. It's much easier to operate a corporation from a terminology perspective, to issue out options. There's a certain level of understanding which is lacking with the LLCs. LLCs requires a relatively more handholding. The state of incorporation, so we've talked about, why should one incorporate? We've talked about the forms of entity. Now we talk about the state of incorporation. Where should I incorporate or form my LLC? Now, the corporations or LLCs, for that matter, are incorporated or formed in the state where they conduct most of their business. So if you're in California, you have the choice of incorporating in California or in Delaware. Delaware is, in my experience, is where 9 out of 10 tech startups get incorporated. Delaware is hugely popular amongst the VCs, amongst the investors. As I tell my clients, if you're in front of an investor and you basically say, hey, I have a Delaware C corporation, those are three boxes that are checked, and then you can go on to the pitching about your business. That just puts the investors at ease with that you have picked the right structure. Now, why is Delaware so popular? Because it has a very well developed and relatively predictable body of corporate law. There's very little that's in the gray area. There's a lot of protection for officers and directors under the Delaware law. Then there is absolutely speed and ease of filing corporate documents. You file a document on a routine basis, and you file a charter on a routine basis in Delaware. Even if it's not expedited, we tend to get it back within 2 to 3 business days, as opposed to California, where it could be anywhere from 7 to 10 business days. If you want to expedite your filing, the cost is less in Delaware as opposed to California. Then there's a separate. So one, that the law is very, very well developed in Delaware, as opposed to other states. Then there is the court system that is also very well developed, and there's a comprehensive court system that only hears business disputes, the corporate disputes. So they are very up to speed on the corporate issues, and like I said, so cost is fairly comparable to California entities. This is what I tell my clients, that if you incorporate in Delaware, but you are you're doing business in California or any other state for that matter, you incorporate in Delaware, you have to qualify as a foreign company in the state where you are doing business, or where you're going to be doing business. Now different states have different rules of when you should qualify, but be clear about that even if you're in a stealth mode, you're just working in your garage, and maybe depending on the rules of that state, you don't need to qualify right away. But eventually, when you start hiring people, when you're renting out space, when when you're selling your, or when you have end users using your app or people buying your product, you will have to qualify in that state. That's when, having a Delaware corporation having to qualify in the state where you're doing business, that's where the double taxation, from a franchise tax perspective also hits. Because in Delaware, you have to pay the franchise tax. If you qualify in California, for example, you have to pay the franchise tax in California as well. Now the Delaware minimum tax is, I believe, the minimum tax is about $400 to $450. In California, it's $800. So if you are a California corporation, of course, then you don't have to, and you're doing business in California, and then you don't have to qualify anywhere else. You just pay your $800 at the end of the year. That's a franchise tax that you pay. On the other hand, if you're a Delaware corporation, you have to pay, and you qualify in California, you absolutely have to pay the $800 that you pay in California. On top of that, you have to pay the $450 annual franchise tax in Delaware. And then, since you will not have an office in Delaware, you will have to have a registered agent to act on behalf of the company to receive notices in Delaware. So you have to have a registered agent as well. That's another. So $450 franchise tax, another $100 to $150 is the registered agent's cost. It comes to about $600 is the additional that you're paying to incorporate in Delaware. And the analysis that you have to do is that if I am going to go out and raise capital, I start off as a California corporation. Like I said, Delaware is what the institutional investors prefer and insist on when they almost always insist on when they fund. So a lot of the times, California corporations have to then reincorporate in Delaware at the time of doing an equity financing. Now that happens mostly when you're talking to the institution, the sophisticated institutional investors, the VCs. But then there is a cost that you have to, then there is a cost of having to reincorporate in California. So that's something that, reincorporate in Delaware. So that's something that should be kept in mind at the time of incorporation. Now here are the factors that determine what kind of entity one should choose. The funding strategy, as I said, if you're going to bootstrap the company, or you're going to use your friends and family to bootstrap with your own money or friends and family, then absolutely LLCs could work as well as a corporation. On the other hand, if you're going to go out and start raising money, be it angels, be it early stage VCs, you're better off starting off as a corporation. Again, if you're talking to VCs and early angel investors, as opposed to a California corporation, you're better off being in Delaware. Taxation, that's another thing that should be kept in mind. If you're looking, like, let's say that you're not going to raise money for a few years, then absolutely, LLCs make sense. There's no double taxation. Profits and losses get passed through. So if the initial stages the company is making has losses, those can be used by the founders to write off other sources of income, so long as you qualify under the tax rules. And then, of course, the reliability and risk should be kept in mind. The management structure is also something that you should think about. Continuity and transferability, and expense and formality. Whether you want to do you want to be in California and save that $600, or you think you'll be talking to investors fairly quickly, and you don't mind paying the extra $600 to be in Delaware, just so that your investors are at ease when you go out and present to them. At this time, I would open it up for questions.
Thank you, Azad. Very good. There's just a handful of questions. I'll start off with one that's pretty simple, but somebody was interested in, privately held companies. There's some, they said there's some very well-known large privately held companies, and of course I can't think of them right off the top, but how are they usually structured?
If it's a I would say corporations mostly. Privately held companies, it's basically until you go public, you are privately held, right? And it depends on, again, depends on whether whether you're going to be it's a family owned business, or it's a business where you have gone out and raised capital, or if you intend to go out and raise capital. So if it's going to be a family owned business, it could be LLC. Whereas if it's a privately held company, but you have raised capital from third parties, from institutional investors, then you may have to be a corporation. Depends on, again, going back to what I had said earlier, depends on the funding.
Thank you. So the next couple of questions are related. When you're forming a corporation or an entity, can you talk about the initial capital infusion? Is that required?
No, the initial capital infusion it's not required, but you have to think about that once you form, be it a LLC or a corporation, right? I mean, there are certain expenses that you have to incur just to form the company. You have legal fees. There's some accounting fees. There's filing fees in those states. Those are so there is some cost associated with forming, with just the formation or with just the incorporation, and where's that fund, who's going to pay for that cost? It may not be huge, but still, if a founder is going to pay it from their pocket, then that's essentially that's a capital that they're infusing into their company. Then it depends on whether you if you're going to go out and start hiring people, and whether those people are going to be working only on equity, or you have to think about the employment laws, or are you required to pay them a minimum wage? Then also that also determines whether you need that initial capital infusion. So there are different circumstances may determine whether an initial capital infusion is required or not, and how much.
Well, thank you. So the second part to that is with formation, and somebody's using their licensing technology either from an individual or licensing from another company, corporation. Is there anything special that needs to be done with respect to the formation? Does a value need to be assigned to it? Is there anything regarding unique with using licensing as the basis of assets put into the formation of the business?
Well, it's so the typical steps. We work with. I work with a lot of startups that that end up licensing technologies from the universities, from educational institutions. There are startups that are started by professors, and then eventually they have to license the technology from the university where the professor is located. Now, the typical step is that you form the company, you issue out the equity to the founders, to the founding team, and then you start negotiating the license. And then in the license negotiation, it's unless you've already done the license agreement, then it's a different ballgame. But typically, the company gets formed, and then you start the negotiations. And those negotiations may go on for some time, but the equity has already been issued to the founders. And then, particularly with companies having licensed technology from educational institutions, the institutions tend to, even with commercial enterprises that license out technology to startups, they tend to keep some equity in the company. So that's that's something that may happen at a later stage after the company has already been formed.
Thank you. There's another one that came over the chat channel. This is, for those companies that are small, this is, I'll read it. So a friend of mine started a small business as joint owners. We have one employee. What's the most basic we should use? And they preface this by saying this is all very complicated. So what's a simple way to do it? What's the basic corporation, LLC? There's no board members, no shareholder stock. Just two people came together to start a business together. What's your advice to that kind of person? I think there's a lot of people come together to start a company together.
Yeah, I would suggest that, you know, you form a company. You should definitely talk to an attorney, and talk to an attorney and determine whether an LLC or a corporation makes sense. Sounds like you know, from the facts that you just mentioned, it sounds like in that case, if there is no, you know, if you just, you know, the two friends have come together and are working together, and there's no intent to go out and raise money, and there's no intent to bring on more people, then, you know, or you just have one employee, then, you know, LLC could be a fairly easy structure, and, you know, it's not complicated. You can keep it as simple as you want. As I said, it's very flexible. But absolutely, you know, you should form a corporate, you know, you should incorporate or form a LLC, so that at least you have your liability, you're protected. There's no personal liability.
Well, thank you, Azad. I don't think we got to all of the questions. It's right at the top of the hour. So thank you for joining us for today's webinar. If you're interested in no-cost one-on-one consulting, please fill out the form at the sbctech.com/contact. If you have any other questions, please email. Thank you. And you can see the email was in the chat window and the screen as well. Thank you.
Thank you.